Hey everyone, we're going to have a quick, rather brief conversation on international law and what it is and how it intersects with all the law that we've been talking about over the course of the semester. So, one of the components of this business law class is that we want to talk about the global environment for business law. And um, this is the international law component of that. We want to think about how these things work, not just domestically, but also interact with countries around the world because we're crossing so many international boundaries with um, business opportunities. And we'll try to put some things in some context and some examples you've probably seen. So, first of all, what is international law? You sometimes see this term, international law. Is it anything? In my view, not really. There's not a whole lot of international law because you have all these separate countries that view themselves as completely independent of anyone else. So, the United States, for instance, we have the Constitution and we believe the Constitution is the absolute highest law. So, if we were to go and sign an international agreement, that would essentially be making our Constitution subservient to that international agreement because we'd be saying, well, we may judge part of this international law unconstitutional, but we still have to do it because we're bound to it. So this has created a lot of consternation in our country about different international treaties, um, international climate change treaties, for instance, international human rights treaties, that we end up not being a signatory to because of our constitutional independence. And that's something that's sort of unique to our nation, not unique to every nation, but it is um, something that is one of our American quirks, is that we don't like to sign into agreements that would bind us to international law. So in general, you don't see a whole lot of international law. It does, or at least not that we're bound to in the United States. It does come up in a few areas. You see sort of the idea of international law through things like the United Nations Declaration of Human Rights. Again, we are not a full signatory to that or a lot of parts of it because we don't want to say that the United Nations is above the United States of America. Um, we sometimes see international law develop in uh, regional trade agreements. So the European Union created a body of international law because these are all still separate nations, but they've become a lot less like, and you get that tension in Europe, right? This is what happened with Brexit. Is Britain is saying we don't want to be bound by the European Union's immigration laws. We judge them to be, uh, not in line with where we want British international law to be. So we need a British law to be. So they need to just walk away from it. Um, but even NAFTA, the North American Free Trade Agreement, created areas of international law that create cooperation and treaties. So we see international law develop through international treaties, through these international bodies like the United Nations that get signatories to join their treaties. But we don't have a whole lot of control in international law. There's a lot of sort of it's suggested that the countries fit in line with certain laws. So uh, international law is, in my view, is sort of a way of understanding and trying to interpret these intersecting bodies of law, but it is not often a thing. So, sort of what we ask is what controls, what law controls? Is it this international law that we've created, or is it our own constitution? If we are signing to a treaty, we are technically binding ourselves to a new contract that um, may supersede our current laws. And again, that's where we have some consternation about it as a country, but it creates a new kind of law. And so let's look at a few examples of areas where this works and how it plays out. Intellectual property is one of the areas where we have some international law to work with. And we have a deep interest in international law because we create intense intellectual property here in the United States and around the world that we want to enforce. So we've looked at like the Michael Jordan shoes, where there were these knockoffs made in Asia, and it's hard to tell the difference. And Nike, an American company, and Michael Jordan was an American brand. They do not want Chinese companies using their using their logos and their shoe designs. It's their intellectual property. So how do you enforce it? Can you stop China and Vietnam from making knockoffs? Up until very recently, that was not much of an option because China was not part of any international legal treaty that would bind them to have trademark and patent rights. It was generally understood that if you sent something into China, if you sold something to China, you could just expect to have it knocked off. If you patented something in China, you could just expect to not to that it would just get knocked off. And part of this was Chinese economic commercial nationalism, that the legal system and its judges showed a strong bend toward Chinese companies and allowed them to knock off without, it was good for China, right? And so they allowed them to do it, and they didn't want to come down on anyone. Now, Michael Jordan and Nike, they registered the Jordan trademark in China, in the Chinese legal system, and then they fought hard for years and finally won a battle that the Chinese judges came down in their favor and enforced a trademark, and actually went and shut down or prevented, fined the factories that were making these knockoffs. And that was a huge win because it showed a shift in the Chinese government's intellectual property system toward honoring foreign brands in the system. So you get the idea that you really have to have a system in each country that's willing to enforce intellectual property rights. And although they may have an intellectual property system, they may not want to enforce it, especially when it comes to foreign entities trying to pursue that enforcement. So this is the challenge that we have, is that we have all these countries that act independently, and they act differently. China acts in its favor. The European Union is fairly neutral because they've got all these different nations. The United States is probably one of the strictest nations in terms of intellectual property. And so what we end up doing with trademark and patent issues is that we kind of play this game with each one, at least the Bedfords. We say, well, where do we want to spend the money trying to trademark things? And so we usually pick some of the big ones, especially if it's something now. If it's a big brand that we are particularly, feel is going to be particularly useful. So the Elastigtag brand is a very strong brand for us, a very strong mark. And we went and we trademarked it pretty much everywhere we could. So we went to, obviously the United States, the European Union, Australia, and New Zealand. They're two separate systems. And then we started getting, you sort of look at the ones in South America that actually enforce. Mexico actually enforces and is pretty good. Now that was a system that's been buoyed up by NAFTA, because we said to enter the North American Free Trade Agreement and promote trade, Mexico has to get more serious about its intellectual property enforcement, and they did. So you've got, so we registered Mexico. I think we picked Chile. I think we might have picked Argentina, a couple South American jurisdictions that do, work hard to enforce. South Africa, we picked. Now, there may be others, China, different systems in different countries, but they may not be that there may not be that much enforcement, and or we may not do that much business there that it just didn't seem worthwhile to us. This gets very expensive because you're paying for these filing fees and annual upkeep, and yet really need an attorney or a firm that can watch all these different, because each country is going to have a different filing date and system and renewals and things. So it's very difficult in that respect. So we just sort of go around and we try to decide. So with Last Tag, we had a very broad stroke with a few trademarks that I filed recently. I have just picked, the United States, Canada, Mexico, EU, Australia. Sort of the big countries where we have some significant business, and then have let the other ones lie alone. One of the other challenges is that sometimes these systems are very different. So the United States, when we're doing patents, the United States allows you to show something to a customer and then file it within a year. Okay, you can disclose it to a customer, you have some time to file it. But if you do that, you lose the right to file in the European Union because they do not allow a disclosure for you before you file it. So we have to really think about this a lot. There's sometimes we want to be working with a customer on an idea, but we think, hey, this is going to have some legs globally, and particularly in Europe, so we don't show it, and we essentially adopt the European patent system so that we can get some international enforcement. I think it's also worth saying something about how you enforce these property rights. Now we've had product get made in China illegally. So there's a company that's knocked off our ElastiTag. It's a patented product, still under patent for about another 8 years. They knocked it off in China and sent it into Australia, and then it was knocked off somewhere else, we don't know where, presumably China, and ended up in Iraq, of all places. Bizarre. And we've had some other products that have gotten knocked off and ended up, I think, in Turkey. So the challenge here is that it's ended up in countries where they don't have very strong legal systems for enforcement. But we can prevent them. We can use the systems where we do have strong enforcement to prevent those products from coming in. So when we know about potential, so in Australia, for instance, we notified our customer, we notified the Customs and Border Patrol there, and they can check shipments, and if they see that product come in, that product code, they can stop it and confiscate those goods. The United States does that too. And so although you might not be able to enforce in China, you can prevent China from selling to international markets like Australia, the United States, which is what they really want to do. And oftentimes, now China's growing and it's getting more of a consumer economy, but oftentimes at least that's practically solved the problem, because if they can't sell and export to the United States, they get disinterested very quickly. Okay, similar questions about contracts and commercial law. So where is a contract? Where can we enforce a contract, right? You've got a contract between two parties, perhaps they're international, and you have to decide where it's going to be enforced. you typically decide this in the contract. There is a provision that is a choice of law provision, and you say what jurisdiction it will be resolved in. I prefer, let me, before I say that, this is also very hard to enforce because if, for instance, Bedford got into a contractual dispute with a company in Costa Rica, and the Costa Rican company wants to sue us, they would bring the lawsuit in Costa Rica, and we just wouldn't show up, right? Because, we don't really go to Costa Rica, and we don't have any assets in Costa Rica, so they have nothing to enforce the contract against, nothing to claim against, right? So we'd probably just say, well, I mean, they wouldn't even bring the lawsuit because it wouldn't make any sense to do it. The way you get around this is that you add in an arbitration provision that says you essentially agree to an international arbitrator that, and then both companies will be bound by the agreement in their own respective countries. Ultimately, you have to enforce that. You have to enforce that judgment somehow, and that comes down to the same issue. But at least it is a better place. And so I prefer to see arbitration agreements in commercial or contractual contracts. But I thought I'd talk a little bit about human rights. And if you watched some of the videos that I've put out on Moodle site on my work in Africa, you'll see that one of the challenges we did a lot of human rights work. We did work in prisons. I did work in anti-human trafficking, with statelessness, so kind of a wide variety of stuff. The challenge again here is enforcement. Countries where human rights violations happen with some frequency often have good laws on their books. For instance, I did a lot of work in Thailand, and they had good laws about human trafficking on the books. The police officers don't want to enforce it, and they are often participants in it. The courts often don't want to enforce it because it is, they're busy with other stuff and they don't have time, or they don't want to see it, or they don't want to admit that it's a problem. And so you have human rights abuses that just continue on because these countries don't have a good mechanism for enforcement. It is almost impossible. If they're not willing to enforce them locally, it's almost impossible to find any other way to enforce it. So, for instance, Syria recently, they are a signatory to an agreement that says it will not use weapons of mass destruction or chemical weapons. And they used nerve gas. We don't have a good way to enforce that treaty, that anti-nerve gas treaty, upon them. So that's why we put a cruise missile vessel near their shore and started lobbing cruise missiles into Syria because we decided there's no legal system. We're going to enforce their participation in that treaty with our bombs. Okay. The point is, it's really hard to enforce it, right? I mean, if you want to get countries to do something, you got to go in with weapons, essentially. So human rights, it's a great thing, and there are the international treaties are fantastic because they are encouraging. The U.S. State Department, if we're talking about trafficking, the U.S. State Department puts out a list every year, and there are 3 different categories, and it's a big black eye for a country to be listed on, level category 2 or category 3 of having some significant human trafficking issues. They're also we take some repercussions on them that that they don't get certain international aid and things if they're on that list. So we have some levers that we can pull that are persuasive, but we don't have a legal mechanism for enforcement upon them. One of the best ways we can get things to happen is, so you've got a human rights issue in, let's say, Equatorial Guinea. So the son of the president from Equatorial Guinea bought and they were doing a lot of terrible things with forced labor and deforesting against some international law, general living conditions, right? And so the son of the president of Equatorial Guinea ended up buying a house in Malibu that I could see from Pepperdine's campus. And so one of the professors at Pepperdine found out about this and started a big push to bring some attention to it. And they ended up, the U.S. government seized their assets. You know, they're foreign. He had like Lamborghinis, and here is Equatorial Guinea in Africa, the country that people are just dying, and he's got this tens of $1 million valued mansion, Lamborghinis, Ferraris. So the FBI just came in and seized this stuff because of the human rights abuses. So we have some sanctions and some levers that we can pull, especially when there are foreign assets involved. If there aren't, it's hard to enforce. And for things that aren't as major, like the work we did in Uganda with the court system, we went in and tried to work within the country and tried to leverage the laws on the books to get them to be effective. And so I think that's a really good way to do it, but that's the long, hard, arduous route. But it's been paying dividends in Uganda with some programs they've started to rectify the situation in the children's courts. And actually, they're running this whole children's court program now as a result of our work. So it's been really, really interesting. So my summary on international law is that there's very little international law to speak of that's very effective. We have these treaties, we have trade group agreements, we have some international contracts, but there's not really, international law is not a thing that exists outside of really individual countries being willing to enforce laws locally. There are some better mechanisms for intellectual property. I should mention that the World Trade Organization, the WTO, is one organization that is trying to promote and foster intellectual property internationally. And to be a part of the World Trade Organization, which is a pretty big deal, you have to have local, in-country intellectual property law that meets certain standards. So copyright longer than 50 years, a patent system, acknowledging that computer software is a form of intellectual property. Those are the kind of things that to be part of the WTO, they require of each country. And so that is a way to help encourage countries, especially developing countries, to improve their intellectual property system. And finally, all of this is difficult to enforce. And it's really trying to find levers that you can pull to encourage that enforcement. And that's not always very easy. So there's a very short overview of international law and how the global legal business environment starts to work.